that this is being taped by C-SPAN, so if you could just absorb 2 rules. One is, it's even more important than usual that you turn off your cell phones. So if you have a cell phone that's not turned off, I hope you'll attend to that. And secondly, an instruction you've never heard before, but there's always a first. It would make a less distracting picture if you were to, after you get your lunch out of your white box or your white bag, if you will take that box or bag and put it down on the floor so that we don't have a lot of white bags and boxes in the picture.
Yes.
So now they're going to need about 2 minutes of noise, not much more than what we've got right now, and then we'll be ready to begin. We waited until you left.
Bartlett, B-A-R-T-L-E-T. L-E-T-T.
I mentioned Professor, I was going to mention to you.
Is that the professor who you were talking to?
Curtis Bradley, Professor Bradley.
Back then, clerkship, public service, because it was a very, it made a huge difference. I don't think I would have been able to.
Good, great.
Are you happy with the way things are going?
Oh, yeah, I hope you poked around. There's plenty of space.
Blown away by how impressive this is and how accurate this is.
We got more planned too, so we got an atrium, big public atrium being planned out here.
Is your, I don't know if you're around today, I know you're probably very busy. I was going to say, is your office still where the dean's office used to be, which is around?
It's
Directly
down
to
in that wing, but I'm in Board of Visitors meeting all day. Yeah,
okay.
we're in town.
That's right.
Y'all can come back.
I'd love to.
Yeah,
would
it's
love
great
to.
to have you.
Thank you.
Which one of you are going to go first?
I'll go first. Give the general program background and summarize essentially what we found, and then Mark's going to talk about the lawyers' involvement.
You can make as much fun of lawyers as you want. I'll come back.
I've got 2 copies. So
Two-fisted.
investigation doesn't stand up.
Charlie Rose, it was nice because they actually did a
Good afternoon. My name is Kate Bartlett. I'm the Dean at Duke Law School, and I'm really pleased to welcome you this afternoon to one of the inaugural events for Duke Law School's new Center for International and Comparative Law. Today's program is a panel discussion on the work of the Independent Inquiry Committee that investigated the United Nations Oil for Food program for Iraq. We'll have further introductions in a moment, but the panelists today are Mr. Paul Volcker, chair of the committee, Mr. Mark Califano, who graduated from this law school in 1988, who was chief legal counsel to the committee, and Professor Jeffrey Meyer, senior legal counsel to the committee. My privilege today is to introduce this as one of several inaugural events to the establishment of this new center at Duke Law School for international and comparative law This is in many respects a long overdue recognition of the tremendous growth in the faculty and programs, lectureships and so on in the international and comparative law area. We have now at Duke quite a number of faculty who teach and do research in the international and comparative law area. It's a remarkable group, particularly for a school of Duke's size, insofar as it has tremendous subject matter diversity, and also at Duke the faculty is not represented or not allied with one particular perspective on international or comparative law, but really represents a broad range of points of view. So we're really extremely pleased with the way this faculty has grown and developed over the last few years. And again, this center is in part a recognition of what we already have, as well as a promise of even greater things to come. We have a very ambitious program in terms of conferences, lectureships. Most of you know that we have 2 first-rate summer institutes. We also have degree programs related to international comparative law. Again, very pleased with what we have, but even more ambitious for the future, and I'm very pleased to be part of this event, which helps kick off the center. One of the reasons this center is off to such a fast start and has so much promise is because Kurt Bradley, who is one of the relatively new members of our faculty, we recruited him from the University of Virginia, has agreed to be the director of the center, and I now turn the program over to him. Kurt.
Thank you, Dean Bartlett, and welcome everyone to our panel discussion. And as the Dean mentioned, will concern the investigation of the United Nations Oil for Food program in Iraq, and it is one of our inaugural events as part of our new Center on International Comparative Law. We have 3 very prominent panelists with us today to talk about this interesting and timely subject, all of whom served in connection with the Independent Inquiry Committee into the UN Oil for Food program, a committee that was appointed by the UN Secretary General, Kofi Annan, in April of 2004, and was then supported by a unanimous UN Security Council resolution. The 3 panelists are, first, we have Paul Volcker, who served as chairman of the Independent Inquiry Committee. Mr. Volcker, certainly well-known by name probably to everyone here, had a very long and distinguished career in government service, including most prominently serving for 2 terms as chairman of the Federal Reserve. Currently, Mr. Volcker is chairing the Board of Trustees of the International Accounting Standards Committee, overseeing a renewed effort to develop consistent, high-quality accounting standards acceptable to all countries. We also have Professor Jeffrey Meyer, who served as Senior Counsel to the Independent Inquiry Committee. Mr. Meyer previously served for 9 years as an Assistant U.S. Attorney, where he prosecuted general federal crimes with some specialization in environmental, financial, and civil rights crimes. He is currently an Associate Professor at Quinnipiac Law School in Connecticut, where he teaches and researches in the areas of international law and criminal law. We also have Mark Califano, who served as Chief Legal Counsel for the Independent Inquiry Committee. Mr. Califano is a graduate of this law school at Duke and previously served for 12 years as an Assistant U.S. Attorney, investigating and prosecuting, in particular, complex white-collar criminal offenses. He is presently the head of litigation at General Electric Commercial Finance. Mr. Meyer and Mr. Califano recently co-authored a book about the UN Oil for Food investigation entitled Good Intentions Corrupted, which also contains an extensive introduction from Mr. Volcker. And I understand that they'll all be doing a book signing for those interested on the 3rd floor after our panel discussion. Each of the panelists will speak today for about 10 to 15 minutes, and then hopefully we'll have at least a few minutes after that to open it up for questions from the audience. Mr. Volcker.
Well, thank you, Professor Bradley and Dean Bartlett. I am conscious we have a very limited amount of time here, but let me say that I think we all feel honored at being here at an inaugural program for the program of international and comparative law. I think one of the things that this investigation will demonstrate is there are a lot of gaps in international law and in a lot to learn from comparative law. And in a globalized world, there's a lot of work to be done. let me say my two associates here who were diligent on the staff and had a leadership position in the staff of about 75 for this investigation, did feel compelled to condense something like 2,500 pages of investigation into something readable. It has not always been my experience that lawyers are successful in making something readable, but I think they have done an exceptionally good job in this respect, and I think the book is actually a pretty good read as a kind of detective story, as well as reflective of a problem in public policy. Let me just set the stage a little bit in terms of the background for the investigation. It arose essentially because of the program arose, the so-called Oil for Food program arose as a result of the sanctions that were placed upon Iraq before the first Gulf War and were maintained after that war. The sanctions were particularly directed toward oil exports from Iraq, which is about their only source of foreign exchange, and they have to import a lot of things. And over time, there was increasing concern and evidence that whatever restraint that was placing on the Iraqi government and Saddam Hussein, that it was proceeding at considerable risk to the general population of Iraq, that nutritional standards were declining, medical standards were impaired, and there was considerable evidence for that. As part of the investigation, we thought we ought to review that evidence, and the worldwide experts that we had on health and nutrition confirmed that it was an approaching crisis by the middle of the 1990s due to the sanctions. So the rather ingenious, I think, and clever idea of an oil for food program arose and was debated. The idea was, under UN surveillance, Iraq would be permitted a limited amount of oil. The proceeds would be escrowed. They would be permitted to buy initially humanitarian goods defined pretty much as food and medicine, later broadened, under UN surveillance, and you would use the escrowed funds to pay for the imported goods. And over time, let me say, I think the evidence is that nutritional standards did improve. I'm not sure the health situation improved much, but it stopped getting worse. That's the basic evidence. So in that sense, the program had success. And of course, the basic idea of the sanctions was to avoid weapons of mass destruction. And we now know that Saddam did not get weapons of mass destruction. So in combination with the inspection, you might argue that the program was successful. I think the question that arose as the Oil for Food program continued was like the old saw, the operation was a success, but the patient died. The patient being, in this case, the UN, has not died, but it has exposed rather grievous weaknesses in the administrative capacity, and I think indeed the political capacity of the United Nations. And the importance of this is that we don't, I think, have any real substitute for the United Nations in the world today. If we had some doubts about that a year or two ago, it's interesting in terms of Lebanon, Korea, Iran, the big hot-button foreign policy issues, we now suddenly turn to the UN to have an answer. Whether the UN is going to be able to produce an answer is in question from a number of directions. But in part, a conclusion from this program is that administrative weaknesses in the UN do impair their capacity to carry out complicated administrative programs. And the Oil for Food program was certainly a complicated administrative program for a variety of reasons. I think what the investigation revealed was that this was a program that had weaknesses from its inception because of varying political concerns among the members of the Security Council. It had weaknesses in terms of the Security Council itself carrying out with discipline the requirements of both the sanctions and the Oil for Food program. The Secretariat of the UN, under the Secretary General, had important administrative responsibilities for carrying out the program, in which there were failures ranging from at least a limited amount of outright corruption to simple errors and inability to exert administrative discipline. There were 9 different UN agencies involved in administering the program in Iraq itself, exercising surveillance and also some distribution of the goods supplied to Iraq with indifferent results. But one result that came out here in terms of a general lesson is the inability of those UN-related agencies to cooperate with each other under a kind of common direction and operate effectively under these conditions. Now, let me say this was a very complicated program to dump on any organization. Over the 7 years of its existence, there was about $110 billion involved in oil exports, $65 billion or so, in humanitarian goods imports of $35–40 billion. It was a big, complicated administrative task, beyond anything that the UN had ever administered, beyond any other humanitarian program, maybe since the Marshall Plan after World War II. That's not an entire excuse for the deficiencies in administration, but I think it has to be borne in mind that this was a very substantial administrative challenge for any organization. I'll let my associates here describe the pluses and minuses and the investigating approaches in more detail. Let me say this investigation was really forced by increasing an aggressive criticism of the UN, particularly in the United States Congress, particularly by the right wing and the political spectrum in the United States, with very strong accusations about corruption and maladministration, and involving the Secretary General himself for reasons that will be explained. So he finally felt he had to, in self-defense, if for no other reason, commission an outside investigation. That's when he called upon me to lead it. I don't think he had any intention, any sense at that time as to how intrusive and how costly and how time-consuming a real investigation would be. In the end, this investigation cost about $35 million, took place over about 18 months. We had 75 more or less professional investigators, accountants, lawyers, investigators, drawn from 30 different countries.
28.
28, close enough for government work or investigations. About half of the investigators came from outside the United States, which was important. In fact, the Chief of Staff, which we called, not Chief of Staff, but
Reed Morden from Canada.
from Canada, very experienced Canadian public official. So it was very much an international effort. As I say, it took about 18 months. I was accompanied on the committee by Richard Goldstone, a name that may be familiar with some of you because he's been very prominent in human rights around the world. He immediately came into prominence 15 years ago, and he headed a very difficult investigation in South Africa at the time apartheid was halted, an investigation into corruption in the South African army and in South African police. Not an easy assignment, and he carried it off with great aplomb. The other, and he had been experienced in human rights areas and war crime tribunals in the UN. The other member of the committee was a Professor Mark Pede, a well-known legal scholar in Switzerland. Not familiar to me, maybe understandably. I said, what is his background? And I was told he was a great expert in money laundering. Of course, my next question was, which side was he on, coming from Switzerland? But it turned out he is a very aggressive advocate of measures against corporate corruption. And I might say, just in passing, that for all the suspicions you may have about Switzerland, and we all did in terms of money laundering and a willingness to cooperate in international legal investigations, they were extremely cooperative beyond any expectation that I think the staff had at the beginning of this investigation. And the findings and the speed of the investigation would not have been possible without fulsome cooperation by the Swiss. I think of all the countries that were involved, and every member state of the United Nations was asked to cooperate, Switzerland was number one. We can maybe discuss later who was number 192 of the members of the United Nations. But let me just stop there, and I do want to say a few words about the recommendations and the conclusions that we reached, but let's talk about the investigation first.
Thank you, Mr. Volcker.
Great. Maybe I'll talk a little bit about, a little more in detail about how this program was supposed to work in theory, and then move on to talking about how it actually worked in practice, as the committee discovered from its investigation in terms of the problems that arose. The basic idea of this program was, of course, to provide humanitarian relief to the Iraqi people. Iraq had been under sanctions since August of 1990, following its invasion of Kuwait. And it wasn't until the end of 1996 that the Oil for Food program finally got going. And that was in large part because of Iraq's resistance to agreeing to the program. Well, why would Iraq and why would Saddam not want to agree to this kind of program? In part, to put pressure on the UN member states, and in particular the UN Security Council that controlled the sanctions, to lift the sanctions altogether and not to continue the sanctions and to ameliorate the humanitarian outcry against the sanctions by having an oil for food program. So by the end of 1996, when the oil first shipped under the program, more than, as Mr. Volcker said, more than $100 billion of transactions would occur. And the program was designed so that if a company purchased oil from Iraq, it had to pay the money not to Saddam or not even to a bank account in Iraq, but to a UN-controlled escrow account. It was actually under contract to a French bank, Banque de Paribas. This bank would hold the money in safekeeping, ready to disperse at such time that Iraq purchased humanitarian goods, essential civilian goods. And in that way, the thought was, we help the Iraqi people, but we don't give money to the regime that might be used for its poisonous purposes. Unfortunately, over time, and perhaps surprisingly for some, Iraq did not actually economically exploit the program at first. During the first few years of the program, it was able to politically manipulate the programs, and I'll talk a little bit about perhaps what the Security Council could have done, but essentially it chose from the outset to favor its friends with the award of contracts and to favor its friends that were in high places, most particularly those countries on the Security Council that Iraq believed were most sympathetic to its cause, Russia, France, and China. In particular, those three countries accounted for nearly half of Iraq's oil sales during the program. And at the same time, the U.S. and the U.K., which of course were less friendly to Iraq's ambitions to have the sanctions lifted, were demoted considerably in terms of the number of contracts they got and largely blacklisted toward the end of the year, toward the end of the program. The program ran from the end of 1996 up until the early 2003 when, of course, the U.S.-led forces toppled the government of Saddam Hussein. Now, over time, after the political manipulation occurred, Iraq, as its ambitions to have the sanctions lifted and the program continued and continued, it was renewed every 6 months by the Security Council. In the fall of 2000, Iraq came up with a plan to essentially derive money under the table from its oil buyers and from the companies to whom that were selling humanitarian goods. And on the oil side, essentially what it told its oil buyers were, you have to pay us a surcharge per barrel of typically 10 cents to 30 cents on each on all the oil that we sell you. How is this money going to be paid? Of course, it's not going to be paid through the UN account. It's going to be paid and would be paid typically through wires through various shell company accounts, usually to a nominee account that the Iraqi Central Bank or one of its ministries held in Jordan and Lebanon. In the particular case of Russian companies that were hit up for this surcharge, the Russian companies paid in cash. We found, we're able to document more than $52 million of cash payments made by Russian companies directly to the Iraqi embassy in Moscow. That was just on the oil side. On the humanitarian goods side, Iraq had a similar plan and essentially just required companies that wanted to sell humanitarian goods to bump up the price by 10% on each contract for goods. And then that contract with the bumped up price was submitted to the UN for approval, and lo and behold, the UN actually approved almost every single one of those kickback inflated contracts. As a result, over the course of the program, Iraq derived by our calculation, about $1.8 billion in illicit income that did not go through the escrow account, obviously income that was diverted in terms of what Iraq could have used to purchase, could have used as purchasing power for additional humanitarian goods. And perhaps to some people's surprise, a large part of this manipulation of the program was actually known to members of the UN, to members of the Security Council, and to members of the United Nations Secretariat, those who work for the Secretary General, and even the Undersecretary General who was in charge of the program, a man named Benon Sivan. Essentially, what we did was we started out this investigation was to focus in large part on the abuses of the program, these kickbacks. We also looked additionally at problems that arose in the program concerning its procurement. And I want to just reflect on that briefly before moving back to the kickback abuses. Part of this program and the success of the program depended on monitoring the oil as it left Iraq and monitoring the humanitarian goods as they came in to Iraq. And now, of course, the UN wasn't really equipped on its own to do that, and it hired private customs inspection companies to do that. Part of the controversy that arose in the program was, and the way that we spent quite a bit of time studying, was the political favoritism that interfered and that meant that the UN did not abide by its own procurement rules in deciding who it was in terms of companies that would get the contracts to inspect the goods going in and out of Iraq. One of the areas that we focused on in particular, and a principal reason why this committee was formed, were allegations concerning the award of a large inspection contract to a Swiss company called Catechna Inspection. Catechna Inspection employed at that time in 1998 the son of Secretary General Kofi Annan. His name was Kojo Annan. And the concern and what we spent a great deal of time looking at was trying to figure out, did the son do anything improper in terms of trying to influence the award of the contract, and did the Secretary General himself do anything improper? In a nutshell, what we were able to determine was that the son indeed was aware and took an active role in trying to influence the award through people he knew at the UN's procurement department in Catechna's favor. On the other hand, we were unable to find any evidence, and this was after going through financial records, grilling the Secretary General about 7 times, going through his email, through his computers, through more than 12 million UN records, that the Secretary General, knew that this particular contract was being awarded. He was not in the chain of required approval for the award of this contract, and we could not find evidence that he was actually advised the contract was being awarded, much less that he took any steps to try to influence the award of the contract in his son's company's favor. What we did find is that the son actively deceived the UN as well as the Secretary General, concerning his continuing role. There was a pretense by the company and the Sun that, hey, we're no longer employing the Sun because we have this contract with the UN, and in fact, the company was making tens of thousands of dollars of secret under-the-table payments through disguised bank accounts in Switzerland and England for the Sun's benefit. So that was part of the procurement aspects that we spent quite a bit of time looking at. On the broader abuse of the program, which really has much broader implications for in terms of the future of the United Nations, we found that both the Security Council and the Secretariat, the UN Secretariat, were at fault in terms of the way they managed the program. In some cases within the UN, as I'll talk about in a moment, there was active corruption among some of the people within the UN. But most importantly, from the Security Council perspective, this was the body that controlled and authorized the program, and any time it could have stopped the program if it was aware of abuses that were going on. However, we found that once allegations became public in the media about the kickbacks in connection with contracts, the Security Council became stalemated. Not surprisingly, with Russia and to a lesser degree France and China stalling efforts to try to address, and US and UK efforts to try to address and to put in protections against these kinds of payments that were going on within the program. I should add that outside of the program, at the same time that these kickbacks were happening in connection with contracts that were actually authorized under the program, Iraq was smuggling immense amounts of its oil. It smuggled, during the years of the program from 96 through 2003, more than $8 billion of its oil. In other words, 4 times the amount that it actually derived through this kickback scheme that I've described. And it did so in large part because, again, the Security Council failed to address and failed to achieve the necessary consensus they need to try to stop these abuses and take effective enforcement action. So that's, I think that's a nutshell in terms of what it is that we looked at most closely. And we looked at the UN, of course, the Secretariat as well, and the Secretary General's office, and we found that there was indeed corruption by Benon Sevan in terms of his receipt of tens of thousands of dollars in cash from an oil contractor under the program from whom Benon Sevan derived an oil allocation. So maybe we'll turn it over to Mr. Califano to talk about the investigation.
Let me just make one other point in transition. The investigation, and Jeffrey was talking mostly about what went on inside the UN. The big corruption, in some sense, of payments, illicit payments, was by the business contractors on the oil side and on humanitarian goods sales, so-called humanitarian goods sales, which was not, in some sense, it should have been monitored better by the UN, but the actual illicit acts were by private businesses. There were about 4,500 businesses that one way or another participated in purchases or sales from Iraq during this period. About half of them made illicit payments, which suggests something about the effectiveness or ineffectiveness of national and international law with respect to what's known as federal corrupt practices. But
Mr. Califano.
And I'm going to continue where Mr. Volcker just left off, because the interesting thing is those companies aren't just shell companies. They include Siemens and Daimler Chrysler and Volvo and a number of other major multinational corporations. And when we did the interviews of those companies, we were astounded to find that in a number of cases their attitude was very glib. When they were frank about it, they would say, this is the currency of the realm. This is what has to happen. It was even more remarkable at how dishonest they would be about admitting it. We had some occasions when we actually found and identified a person who had signed the side agreements for one company. We asked them to bring the person to an interview. They said they couldn't locate the person because he was no longer with them. Before the meeting, we actually found out that he was in an office about 5 miles down the road. After we confirmed with them that they had, quote, looked as hard as they could, we pointed out that he still had an address at the company, which was Siemens, by the way, and he was only 5 minutes away. That is the kind of thing that happens in this particular situation in international markets. The one thing that is most important for all of you to gather and take home from this is that politics and commerce are so inextricably intertwined in operations like this that it is very important to determine what drives what. We noticed that some of the most sensitive organizations and member states here had their ear to the ground on almost every potential economic possibility that could exist in Iraq after sanctions arose and would be lifted, and they were focusing very closely on that. Iraq, for its own business, focused, if you notice, especially in our book, in the first couple of phases of this program, what grew to appear is that they focused on selling oil to 3 of the permanent members of the Security Council most sympathetic to their concerns and arguments: Russia, France, and China. When you look back at the humanitarian contracts that they let, the high numbers of contracts and volume of business were actually focused not only on those countries, but on some of the Middle Eastern countries which were as closely aligned as those countries were outside of the Security Council. Now, the one thing I want to talk to you all about is that there are a lot of students here and a lot of people who justifiably have generated the interest that this kind of a program deserves. I will tell you right now, this will not be the last time that the UN gets involved in something like this. It is very clear. Although I think they have a very different opinion of how these investigations went, and they are not at all thrilled about having another one, my bet is you will see another. And if you have any interest at all in what good public government and good commerce is, you should look at a career or look at having an opportunity to work in one of these investigations. I'm going to tell you a little bit about the makeup of the staff. Our staff was mostly people from the countries outside of the United States. The lawyers who worked on this included 2 sets of lawyers. At some of the higher levels, we had very experienced career prosecutors. I spent 12 years doing this kind of work, especially international work. We had partnerships with some of the most professional and well-regarded prosecutors in the world, the Milan Public Prosecutor's Office, some of the French magistrates, the Swiss Federal Prosecutor's Office and the magistrates there. And those kind of partnerships had not ever been used in an investigation like this. The kind of young people we had involved in this included some young lawyers from Iran, from Lebanon, young people from Syria and Canada, people who held passports in Spain and in India and in all parts of the world where, quite frankly, most of us in the very provincial world of the United States do not think of them as being able to contribute to an effective and rapid and efficient investigation. This had to happen in 1 year. And everybody who had an interest in seeing this end and not being very successful wanted to race us, or at least test us, to make sure that we ran out of time. So we did some things that I don't think anybody expected us to do. One of the first things was we insisted that this was not going to be an internal administrative investigation. The Security Council was fair game, as were each of the member states, and that did not make anybody happy, including the United States of America. Jeff's group had to negotiate with each one of the foreign ministries who we got cables from, who we interviewed their staff on, who are active in this program, to have access to that material. We got access that no prosecutor ever had. And I think if you remember, at the beginning of our investigation, those of you who ever followed the public accounts, we were criticized heavily because we did not have subpoena power. I cannot tell you, as a prosecutor who has worked in multiple jurisdictions, what a canard that is. Okay? What that tells you is that the U.S. prosecutors and the U.S. investigators had no effect outside the United States, except in those areas that were controlled in part by the U.S. military. That includes Iraq. And even then, we actually were the people who assisted them in getting a lot of key evidence that they used in a number of their reports and in showing them how to use it. They had a lot of cynicism when they started our investigation, when they looked at us, and by the time we finished, we had the respect of the congressional committees who were spearheading those investigations, and we have been instrumental in the prosecutions that have been conducted by U.S. and foreign prosecutors on this matter. What we did was very simple. We had access to diplomatically protected transactional information. Every contract, every payment, every approval that was done in this program was at our hands and was protected from any kind of service of process. We also had access, because we were aggressive at getting into Iraq very early, at a number of documents generated by the ministries in putting this process together. And we translated them very carefully, not just with standard translators, but with lawyers who were interested and engaged and wanted to understand how the program worked. Because we had those things, we could offer to any prosecutor in the world a complete set of records. For example, of every contract which was allocated to high public officials who were on those wonderful lists that appeared after the invasion. The French were remarkably responsive to this. The Italians were as well, and as were a number of countries which I cannot mention here today. But it was effective in that we would give them this information. We would often actively translate it. We would help certify it for their processes. And in exchange, we asked that in the course of their fully authorized investigation, we have access to their evidence. That was something that nobody expected us to do. And that was something that gave us a scope and a rapid reach that was unprecedented. It was so successful that those European prosecutors came back at the end of our investigation and asked if we could open something up like that at the UN permanently. Remember, because we were not party to a treaty and we were UN officials, experts on mission, we were not subject to the normal treaty exchanges of evidence. Prosecutors were very effectively using that to meet with us, to exchange information rapidly and put cases together in a span of months that would normally take years. And I cannot tell you how much fun it was to do. I came to this school not because I wanted to be a lawyer, but because I wanted to be a journalist. I discovered trial practice and I loved it. And I really discovered in the course of this that lawyers don't just have to be litigators. They can actually have an effective role in helping show what is really wrong with an organization and a political process and what can really be done to fix it. But if you take anything with you, there is a lot of work to be done in the way that international commerce works. And if you don't start laying the rules down and making people behave across all sorts of jurisdictions, you're going to have an uphill battle to making sure people who really need that kind of aid get it. One of the things we noticed is that the sale of commodities in this program did not track the commodity price index. Not only if we added the illegal kickbacks, or we added the cost and the risk of doing business in Iraq, did that number deviate. It was often, that is, the price that the Iraqis paid per metric ton of various wheat and grains, 3 to 4 times the market price. It's outrageous. And it's the kind of thing that that governments and the International Monetary Fund and the World Bank continually run into in their programs. And it's something that will require an awful lot of work in the future. I'm going to stop there because I think hopefully we have questions, unless Mr. Volcker has some more to add.
Well, I think we have some questions, but let me just say, in terms of young lawyers, I was impressed by the enthusiasm that they all had and the morale that was maintained throughout this process. And they keep running into a problem. As the investigation ran down, they were all sad that the investigation was over because they hadn't done anything so exciting in their careers. And they were wondering, where could the next investigation be, or wherever? Where else can we have some sense of affecting public policy? Let me just say, let's open it to questions, but we did make a series of recommendations. A lot of those recommendations have been worked on internally in the United Nations. They simply did not have the auditing, the accounting, the inspection, staffs, or discipline they should have had. They had a refusal to infuse the institution to avoid responsibility. Every time a question arose, it would be somebody else's responsibility. And there was a lot of occasion here for passing the buck, and that kind of thing just has to end. There was no conflict of interest rules, or not effective ones anyway. There were no rules for financial reporting of officials. A lot of that is in the process of change, but I still have, and I'm not alone, severe doubts as to whether they have done enough structurally to provide the kind of administrative controls and administrative discipline that this organization sorely needs. And unhappily, there is a great deal of resistance in an organization of 192 member states, each with one vote, to make the kind of structural administrative changes that this investigation clearly revealed the need for. Most of it was not new. It's stuff that people suspected before. But here was the evidence spelled out in clearly a way that could not, I think, be denied. And it's a pretty good read, too. But let us go to questions, if not answers.
Thank you. Let's begin by thanking our panelists for the very interesting presentation. And we now have about 10 minutes or so for questions from the audience, and we can pose questions for any of the panelists. And then as a reminder, they'll then move outside for a book signing right after the panel discussion. So any questions? Yes, over there.
I'd be a little interested in hearing a little more about how one goes about grilling the head of the United Nations. Did you get him alone in a dark room with a headlamp and interrogate him, or how was that process done?
The kind of process you use for any official in a complex white-collar investigation is very methodical. We could go into a lot of details about how prosecutors do it, and experienced prosecutors have done it in this case. It involves making sure you have your facts and making sure you walk them through a lot of what they were involved in during this. And you often show documents. You might often press people. But one of the things you have to realize is we had a fact and a fact-finding mission here. So there was a little less of a gotcha, which is not necessary anyway in a lot of cases because of the complexity. But I will tell you, we did half a dozen interviews with Secretary General Kofi Annan. They were very long. They often involved Mr. Volcker and Sir Richard Goldstone. We did as many of Boutros Boutros-Ghali. And Boutros-Ghali and Kofi Annan both subjected all of their personal financial records to review.
Boutros-Ghali was Kofi Annan's predecessor as Secretary General, and he was Secretary General when the program started.
Additional questions? Yes, over on this side of the room.
Yeah. You talk a lot about how commerce and intergovernmental organizations like the UN are intertwined. So given that the UN is primarily concerned with governments, how do you see, given that there was a lot of commercial corruption here, modifying UN procedures to regulate international commerce and like governmental humanitarian aid ventures like this?
How do we see multinational?
How do you see like developing sort of like a legal regime for sort of working with international commercial interests like Siemens, Volvo, and other transnational corporations?
There's an international convention on foreign corrupt practices, which is something that has helped encourage not only developing that kind of law in the developed nations and the undeveloped nations, but also reviews those laws and their enforcement practices on a very, very detailed level. It's probably the most encouraging development that's occurred over the last 20 years. But it's clearly, as we've found, not enough. Some of those laws, and because of the way prosecuting regimes work in various countries, they're still subject to very low resources, difficulty in getting the evidence, and often, but not always, some political pressure. Mr. Volcker may have more to say about the concerns that have been voiced in other areas than this.
Well, we certainly have revealed weaknesses in national and international law in this process. The biggest single violator, biggest single company making illicit payments was not Russian or Chinese or French. It was good old Australia. Australia was a traditional exporter of wheat to Iraq. This is a big market for Australia. And obviously wheat came in within the humanitarian goods imports. Australian wheat exports are controlled totally every place by something called the Australian Wheat Board. And over the course of this program, they paid more illicit payments to Iraq than anybody else. A couple of $100 million. They were one of the biggest importers. They denied this through the investigation, but we found a fair amount of evidence, and it was all printed in our report. This has become an enormous political issue in Australia because there are allegations that the government was aware of it, denied by the government. Even the Prime Minister may have been aware of it and said okay, and of course, from the standpoint of Australian farmers, their reaction was, well, of course we bribed them. How else do you think you get a market? Otherwise, the Americans would have gotten it. I mean, that's the kind of attitude you have in international commerce. But there is a major investigation going on inside Australia with subpoenas, with all kinds of police power. They are supposed to report finally within a couple of weeks. My impression is the evidence that they have found, which is voluminous, supports our initial allegations in our report. And whether they're going to find the government is involved itself is, I don't know what they're going to say. That report comes out in 2 or 3 weeks, I think. And we will see. But it'll be interesting how they apply Australian law to the Australian Wheat Board and the officials that manage this. I'm told as a non-lawyer that one of the tricky things is even under American law is directed against the bribery of a foreign official. The argument will be made in this case, they weren't bribing foreign officials, you were bribing the government of Iraq, which is a little different. It was officially sanctioned bribery, so to speak. And it's not clear, I guess, whether American anti-corruption law applies to that particular act. Now, I have great respect or otherwise for American prosecutors that seem to find all kinds of ways to charge people with various laws when the law doesn't directly apply. But other countries may not be as assiduous. Russia was the biggest single supplier in total as a country. Clearly they were involved in illicit acts, cash payments among other things. I know of no move toward investigation of anything in Russia when it's quite clear that the government in that case was involved rather directly.
Thank you. I think I saw a question over here.
The
Yes.
impression is that the UN personnel are above the law, that no criminal law operates as a deterrence. They're not subject to prosecution anywhere.
There's an interesting, you want to comment on that? There's an interesting aspect of this, which is an important one to realize. We don't think of it here because of the way we use the rule of law in our day-to-day life. Anytime a foreign official, a U.S. diplomat, operates in a foreign country, that kind of diplomatic protection prevents him from being threatened or extorted by what I would call an improper use of foreign law or any proper use of foreign law, even if it's technically proper. The UN officials that operate in that organization have that same issue when they work outside the U.S. as when they work inside the U.S., and their instant response to this was very similar. But what had to happen, and what we did, was very aggressive, and it had never been done in the history of the United Nations. We secured people's offices with no notice. We asked them to leave, and we completely cleaned them out. We did imaging of well over 100 hard drives in that institution. We didn't, I wouldn't say we threw anybody on the ground and slapped the cuffs on them, but what we were able to do is gather information very quickly, is to make it very clear that either there was cooperation or that person was not going to be able to hold a position at the UN. We'd ask for disciplinary. And the interesting thing about the United Nations officials is that one of the biggest hammers over anybody's head, even improperly, was the threat of losing your visa. Many people come from foreign countries that do not have the kind of atmosphere and protections and economic benefits that the United States has. And so losing that visa was a devastating thing. We tried the best we could do. We actually prepared a very significant case, I think, and extraordinary amount of evidence against Mr. Savan, and we actually proceeded in this investigation and with a slightly different additional purpose in mind, which is when we gathered this information, we preserved it as evidence. And at the end of our investigation, when we had inquiries from prosecutors, we had inquiries from 60 different law enforcement and regulatory authorities in 27 countries, and several of them from here, we literally presented them packages. Very well preserved, organized, with the appropriate direction and instruction that would allow them to go after people, including people in the United Nations. And the UN took a very active stance in which they said that if there was a case made against somebody, they would waive. And they did on a number of occasions. If you've read about the procurement officials, some of those waivers happen faster than you can blink an eye, which is significant in keeping an organization able to operate and still making sure these people are exposed to the kind of criminal prosecution that probably is necessary, I think.
I think the United Nations in concept has taken the position that if there is evidence that a law has been broken, they will waive immunity. Now, you know, all kinds of questions arise to how much evidence they need that the law has been broken. A bigger problem, in a way, frankly, is some of the staff practices and behavior. They cannot fire anybody without going through some administrative procedure. And there have been some very peculiar results where people have been found more or less red-handed. And the UN tries to fire them, and does fire them, and they appeal to this board, and their fellow employees say, no, put them back on the staff or restore their pension or whatever. It's a very protective, staff-protected system. which somehow is going to have to change too, but it's part of the culture of the place.
I think we have time for at least one more question here. Yes, over there. Yes, sir.
What about the general idea of upgrading the quality of the bureaucracy that runs the UN through the hiring process or what? I understand they come from all these different countries, they're appointed from different sources, and they come in during the mid-30s and they stay and they're retired in their early 60s, and they just stay there. And who's grading their papers? How good are they? What can be done to upgrade them?
Well, my impression is, and I'm sure it's many other people's impression, that it's really very mixed. You've got a mixture of people who are there, experienced, expert in their areas, and many of the UN agencies, we rely upon them, the World Health Agency, to take one example, but humanitarian experts, and within the Secretariat itself. Some of them are good administrators and some are not, but they're mixed up with the people who are there for basically political reasons, and it's very hard to fire them, as I just indicated. And altogether, it's a dispiriting place, I think, for many people to work, because those that are energetic and capable and interested find they're kind of operating in a molasses bowl, to put it that way. And that's one of the things that has to change. One of our principal recommendations is that as presently organized, it may be practically impossible to get the professional, active, effective, disciplined staff, because the Secretary General, who's in charge of the Secretariat, and who has a single line description in the charter, Chief Administrative Officer, is, put no finer point on it, maybe exaggerate a bit, is institutionally unfit to administer. Now, I say that not just because of his experience, they typically are diplomats who are appointed there, but all the pressure comes on the Secretary General to be a negotiator, to be a facilitator, to be a diplomat. That's his job, as he perceives it now. And in that job, dealing with a lot of recalcitrant members of the Security Council with different views, 192 members, is simply not conducive to running a tight administrative ship. So we concluded if you're going to do that, you better have somebody who is really the Chief Administrative Officer. And since that title's already taken, we would call him Chief Operations Officer. But there is nobody there that has real authority over the staff apart from the Secretary General, who has the disabilities that I mentioned. He now admits, he writes about it himself. Somebody ought to be there appointed very much the way the Secretary General is appointed, and he's in charge of administration. He should report to the General Assembly, in my view. And when there aren't enough auditors, when there's not enough inspection team, when people keep passing the buck, you go to him. He should be the guy responsible. And that doesn't work now. And maybe it'll never work, but that's what our recommendation is.
That will conclude our panel discussion. Thanks once again for the distinguished panelists. And if you're interested in the book and talking with the authors, they'll be out there soon.